Part 2 will introduce you to the following: school attendance, the Fourth Amendment, commonly known as search and seizure. This section will start and end with the famous TLO versus State of New Jersey decision. Abuse and neglect, student records, or FERPA, the Federal Education Rights and Privacy Act, expulsion for general and special education, and Indiana's Article 7, which is the Individuals with Disabilities Education Act in Indiana, and violations of the IDEA process and procedures. School attendance is, of course, very important. The legal authority for school attendance lies in the common law doctrine commonly known as parens parenti, or parents to all persons. The state acts as the guardian over everyone and therefore has the authority to protect those who are not legally competent to act in their own behalf. There are exceptions, of course. For example, the Amish, who do not send their children to school through 12th grade, but generally only through 8th grade. And there are the establishment of homeschooling rules and procedures. The schools can proceed against a parent and child for non-attendance for truancy, illness without a valid excuse, marriage, and or vaccinations. In Indiana, under Indiana Code 20-8.1-3-34, compulsory attendance for a full day, the duty of the parent. Note this part. It is unlawful for a parent to fail, neglect, or refuse to send his child to a public school for the full term as required under this chapter, unless the child is being provided with instruction equivalent to that given in the public schools. This section does not apply during any period where the child is excused from attendance under this chapter. Thus, the authority for homeschooling. The next group of slides has to do with the Fourth Amendment. Under New Jersey versus TLO, the Supreme Court held that the Fourth Amendment protects students from unreasonable searches by school officials. However, the court did not demand that school officials obtain a warrant or have probable cause in order to search students. Generally, the rule of thumb here is if there's reasonable cause to believe that a child has within their locker something that would be of dangerous proportions to the school, the youngster involved, or others, then the school has the right to search that locker. There's always the balance, and I know you've seen this in other cases, between the privacy interests of students and the special need of searches in the public schools. There are two standards that make this public school search reasonable. One, it must be justified at its inception when there are reasonable grounds for suspecting that the search will turn up evidence that the student has violated or is in violation of either the law or rules of the school. Secondly, it must be reasonably related in scope to the circumstances which justified the interference in the first place. The search cannot be excessively intrusive in light of the age or sex of the student and nature of the infraction. Meaning, thus, if you anticipate that a youngster may have stolen something or has a weapon on him, it is still illegal to strip search that child. In the case of Edwards versus Reese, the court assumed for the purposes of the opinion that questioning of a student for 20 minutes in the principal's office on evidence that the student has called in a bomb threat was a seizure, but found that the seizure was reasonable. In the Hayes versus Unified School District 377, it was found that confinement of disruptive handicapped children in a timeout room is also reasonable. By extension, the courts have allowed for drug searches by dogs, with the exception that when a search is done by the consent of the student, sometimes as the school officials have initiated that search, where there's a line that the officials may not cross that we've just discussed in terms of student changing clothes in a locker room. And loco parentis means in place of the parent. Should you take that child on a field trip and the child breaks a rule, school rules should continue to be in place. And therefore, when you as an administrator or as a teacher act in place of the parent, with permission of the parent, you are legally sound. You always need to remember the general rule of the Fourth Amendment from the TLO decision. This reasonableness standard will, we trust, neither unduly burden the efforts of the school authorities to maintain order in their schools, nor authorize unrestrained intrusions upon the privacy of school children. Very important to keep that in mind. The next section has to do with suspected abuse and neglect. It is law in every state that I'm aware of, and a requirement of the Federal Child Abuse Prevention and Treatment Act of 1974 and Indiana law and other laws in 1997 and beyond, that should an administrator or teacher see that a youngster may have been neglected or abused, they are responsible to contact Child Protective Services. If that child is in need of services before the 18th birthday of the child. If you take the responsibility to turn in a child or parent as a result of abuse and neglect, you are not liable for potential damages. However, should you not do that, and the child is hurt or injured with your full knowledge, you are then liable and criminally responsible for anything that may happen to that child. It's very important that you err on the side of caution, and if you believe abuse or neglect is occurring, to call in that referral. Many administrators prefer that that be done with a counselor in the case of a teacher, but even in the case of a custodian, it must be done, and the administrators should be made aware of it. The next section on student records speaks to the Federal Education Rights and Privacy Act of 1974. It should be noted that parents have the right to inspect all records the school maintains, or the student may do so at age 18. However, please keep in mind that having two sets of records is not a legal boundary that the parent has to cross. All records means all records. No Child Left Behind and the Patriot Act requires that the military receive access to secondary students' directory information. Normally your school receives a request for 11th and 12th graders to mail out information to. The Patriot Act further requires that if you have a child that has committed a major offense, is expelled from your school, and then tries or does transfer to another school, it is the responsibility of the school to report those acts to the receiving school. Should a child be involved in a serious act, even in their senior year, it is the responsibility of the school to report that to the college or university or trade school that their child may enroll in. There are also issues regarding student grades, whether to post or not post those grades. It is not legal to post grades with students' names on them or identifying information. It is legal, according to a U.S. Supreme Court decision, to allow peer group grading. The next section is in some detail, having to do with Indiana's expulsion law. It is true in every state that there are provisions in which a school may expel a child. In Indiana, a principal may suspend a child for up to 10 days pending expulsion. During these 10 days, a meeting must take place. Paperwork must be sent to the parent. The parent or student, if over 18, has the right to explain their conduct, and they also have the right to representation during the hearing process. Following the suspension, there must be a written statement to the parents or guardian of the suspended student describing the student's misconduct and the action taken by the principal, and further, during the appeal process, the action taken by the school district or corporation. This is a generally true process regardless of the state that you may be in. If you'll notice in the appeal process, and I apologize for the small print, you will notice a number of steps that must be taken by that school, corporation, or district to make sure that due process has been accorded to the child. If you look in the slide that begins the judicial role, judicial review of a governing body's action, that's the school board, under this chapter by a circuit or superior court in which a student resides, the county in which the student resides, who is subject of the governing body's action, is limited to the issue of whether the governing body acted without following the procedure required under this chapter. As long as your school district, your school itself, and the district or corporation follows the law, there are no issues. For special education students, there are additional requirements, such as having a manifest determination to ensure that the discipline or the issue that the child was involved in is not a product of their disability. If it's determined that it's a product of their disability, then a case conference could be conducted to change placement or to go on homebound, as it were. If it's found to be not a product of their disability, the school can then proceed with an expulsion. It is very true that special education students receive additional due process protections. I might note, as noted in the summary of the process, in general, schools have specific suspension and expulsion overview within the school's handbook or code of conduct based upon state law. In some cases, the school and the juvenile court will be involved on a side-by-side basis in determining whether the offense is of a delinquent nature. Regardless of court outcomes, the schools may proceed with their own discipline based on law and the student code of conduct. It is always important that the student's due process rights are upheld, regardless of the type of offense that's taken place. Of course, those special needs students facing expulsion must also have manifest determination hearings to ensure that the offense is not a product of their disability that has led to potential expulsion. Article 7 of the Indiana Code speaks to the specific procedures that must occur for special needs students. You should make sure that you consult the special ed code in your state based upon the Federal Individuals with Disabilities Act, or IDEA. Under Article 7, which is an interpretation in Indiana of 94.142, or the Education for All Handicapped Children Act, which is now known as the Individuals with Disabilities Education Improvement Act of 2004, with the original act starting in 1975, requires identification, evaluation, placement, procedural safeguards, and other due process rights. At times, special education students will be involved in receiving general education intervention, or RTI, response to instruction, and or instead of being found in need of special ed services, they'll be found in need of accommodations under Section 504 of the Rehabilitation Act of 1973. This last section involves violation of IDEA. It's very important that you take a look at these potential violations. I'll point out a few. The failure to devise an appropriate IEP or individual education plan based on the child's individual needs. The failure to allow parents to meaningfully participate. The failure to give a notice of rights and plan meetings, and the failure to train staff and aides in the child's areas of disability. Further violations of IDEA involve failure to maintain proper records, to involve and train parents in the child's area of disability, to conduct necessary evaluations, to offer extended year services for children, to convene case conference meetings anytime a parent asks, and to notice that a child was in need of special education services despite the evidence that the child was struggling academically and behaviorally, and rather than identify the child as special ed, the child is suspended constantly. Be sure that you allow special needs children to participate in extracurricular activities to the same extent as non-disabled youngsters when the child could participate given accommodations by the school. These parts on special ed obviously are a very small summary of the many acts that are involved in special education. I encourage you to consult with your central office or special ed specialist in your school in regards to being an effective administrator for special education students.